Hello, everyone. My name is Gleb Papyshev, submission number 3718. Today, I'm going to present a paper titled Balancing the Trade-off Between Regulation and Innovation for Artificial Intelligence, an analysis of top-down command and control and bottom-up self-regulatory approaches. I'm working on this paper together with Keith Chan and Masaru Yarime. Despite the difficulty of the regulatory task and uncertainty associated with AI's impacts, several countries have started the race to AI regulation and have come up with unique and innovative approaches to regulating this technology. The spectrum of regulatory proposals spans from hard laws and prohibition of certain systems to industry self-regulation based on AI ethics. While the EU and China rolled out relatively strict regulations, the governance of this technology elsewhere is mostly conducted through soft law mechanisms. This spurs the ongoing debate about which of the two approaches better promotes consumer welfare. Both the top-down stringent approach and the bottom-up ethics-based approach have been criticized in the academic literature. While strict regulatory requirements may better protect society against risks of AI technologies, they also tend to hinder the pace of innovation. It is unclear to policymakers and researchers which approach maximizes consumer welfare and under what conditions. The conceptual difficulty in addressing this dichotomy partly stems from the lack of a common framework which incorporates both sides of the argument. In response to this gap in the literature, this paper has developed a model to address the following interrelated questions. The first question is, what are the advantages and disadvantages of the two regulatory approaches? What institutional factors influence the outcome of the two approaches? And how should governments optimally balance the trade-off between AI innovation and consumer protection in general? To empirically ground our conception of different levels of regulatory stringency, we first examine the regulatory proposals from the EU, the UK, the US, Russia, and China. The proposed level of regulatory stringency depends on how much they prioritize stimulating AI innovation in the private sector at the expense of consumer protection. We then build a game theoretical model which examines the complex incentive dynamics between innovation and consumer protection. It is important to acknowledge that our model is not designed to be explanatory for the differences in regulatory approaches chosen by different countries, because the country's choice could be irrational, affected by path dependence, or be the derivative of the political regimes in power. Instead, our model intends to contribute to the normative discussion on the optimal approach in regulating AI and clarify the current academic and policy debates by pointing out how the optimal regulatory stringency is conditional on its institutional environments. In this paper, we look at the global landscape of AI regulation to highlight two major regulatory approaches, the top-down command and control approach and the bottom-up self-regulatory approach. By top-down command and control approach, we understand regulatory approaches where the governments control access to the market for certain types of AI systems through legally binding regulations. On the other hand, bottom-up self-regulatory approach is based on the idea of industry self-regulation through non-enforceable ethical principles for AI. We use the case studies of the EU, the US, if the Algorithmic Accountability Act is adopted, and China to illustrate proposals in the first group, and cases from Russia and the UK for the second group. While the scope of regulations is big, we are particularly interested in pinpointing the mechanisms for revealing potential exploitation to the consumers from the regulatory documents. The EU adopts a risk-based approach to regulation, focusing on harm prevention from AI risks. In practice, the approach usually manifests as prioritizing the mitigation of rarer risks with potentially high impact over those that are more likely but have a potentially smaller impact. In the same vein, the AI Act distinguishes three groups of AI systems based on risk levels: prohibited systems, high-risk systems, and low-risk systems. The use of systems of the first type is wholly forbidden. Strict regulatory frameworks will be created for systems of the second time. A soft regime of self-regulation will be imposed on the third type. Especially relevant to this paper, high-risk systems are required to be transparent and interpretable by humans. To meet these conditions, firms providing high-risk AI systems should supply information about the goal of developing the systems, as well as their accuracy and reliability, the data used for training, validation, and testing of systems, and risks that could be potentially caused by implementing these systems. Currently, the landscape of regulatory interventions for AI in the US can be characterized by a high degree of fragmentation. Although different states have enacted their own regulations for this technology, a federal level regulation is still lacking. Nevertheless, a federal level legislative proposal titled the Algorithmic Accountability Act has been put forward, which, if approved, will create a regulatory system in the US similar in stringency to that of the EU. The regulation will be applied to those who build the decision-making systems and those who deploy them, and the companies will have to provide an impact assessment report. Especially relevant to this paper, the Algorithmic Accountability Act proposes to establish a publicly accessible repository of the information about each automated decision system from which the Federal Trade Commission received the report. The purposes of the repository are to inform consumers about the automated decision systems that they may interact with, to allow researchers and advocates to study the effects of these systems, and to ensure their compliance with the Algorithmic Accountability Act. Though it is not clear at this point whether the act will be enacted, the legislative proposal provides us with vivid examples of transparency measures which reveal the exploitative potential of automated decision systems to consumers. To illustrate a unique regulatory approach in China, we focus on Internet Information Service algorithmic recommendation management provisions issued by the Cyberspace Administration of China. Especially relevant to this paper is the fact that the providers, according to this regulation, the providers of AI systems in China must inform the users about their services and how these algorithmic recommendations are designed. Technical solutions are encouraged to optimize the transparency and understandability of the algorithms. If an algorithm has significant influences on people's behavior, the provider should give an explanation of the algorithm's working logic. Mechanism of manual intervention should be incorporated so that users can opt out or switch off the recommendation algorithms or delete the tags used for recommendations associated with their persona. These transparency measures are clear examples of regulatory mechanisms to reveal the exploitative potential of algorithmic recommendation services to consumers. The Russian regulatory documents put a high emphasis on industry self-regulation, as well as on the involvement of industry players in the process of drafting policy documents. Thus, the foundational regulatory document for AI in Russia articulates a strategic vision in favor of deregulation and industry self-regulation rather than strict governmental oversight. Though the document does proclaim that it is adopting a risk-based approach to regulation, it is unclear how risks would be categorized and how these risks would affect the development and deployment of AI systems. Unlike the previous three jurisdictions discussed before, there are no mechanisms through which the government review the AI systems developed by private companies before they enter the market. There are no mechanisms through which consumers have access to information about the data or algorithms behind AI systems, and there are no mechanisms to penalize companies that violate the ethical provisions. Thus, the Russian government adopts a hands-off approach to regulating AI with minimal oversight and transparency. There are no regulations specific to AI in the UK yet. Nevertheless, the government issued a policy paper titled Establishing a Pro-Innovation Approach to Regulating AI on July 20th, 2022. The document articulates a vision of institutional architecture for regulating AI built on four key pillars: pro-innovation, light touch, coherence, proportionality, and adaptability. Instead of this centralization, the document proposes to assess the impacts of AI technologies with the particular context where the technologies are implemented. An essential feature of the UK approach is that it does not come up with a future-proof definition of AI, unlike the regulatory initiatives in the EU. Instead, the document proposes to put no boundaries on what constitutes AI and leave regulators or relevant bodies to decide what technology and systems are in scope as they see fit. The UK intentionally deviates from the approach chosen in the EU because, from their point of view, the European approach could hinder innovation. Being light touch, the framework will be introduced as non-statutory. An enforcement mechanism, including possible technical standards for AI, will be introduced later. As such, the UK is relatively hands-off in regulating AI, and no mechanism for revealing the exploitative potential of AI system to consumers has been discussed in the documents. This model investigates the strategic incentives of the AI industry to innovate and exploit their algorithms under various institutional environments. In particular, we study the intricate effects of two institutional parameters. The probability, K, that the exploitative practices of the domestic AI industry are revealed to the public. Our primary interest is the gray area where firms may covertly exploit consumers out of profit motive in a way that is within legal boundaries. As such, it is not prosecution of top-down prohibition, but revelation of these exploitative practices to consumers that acts as a deterrent. The consumers' knowledge of what they are actually consuming and their informed response following the revelation is both a hallmark of consumer protection and a disciplining device for AI firms in such gray area. In the context of this research, the examples of such mechanisms include: in the EU, firms must first ensure the transparency and interoperability of their AI systems and file relevant technical documentation to the government before entering the market. In China, providers of recommendation algorithms must file self-assessment reports to the government and inform the user about their services and how these algorithmic recommendations are designed. In the US, the Algorithmic Accountability Act proposes a repository of publicly available information about the usage of automated decision-making systems. The second key parameter is the degree of foreign competition, theta, facing the domestic AI industry. Foreign competitive pressure is naturally a driving force behind firms' innovation and exploitation decisions. But the presence of competitive foreign substitutes also determines the extent of potential treatment a government should show towards the local AI industry. Note that the degree of foreign competition is by no means solely driven by technological differences. Economic policies play a key role as well. For instance, a government can influence the foreign competitive pressure facing the local AI firm by restricting or opening access to the domestic market for foreign companies, adjusting the subsidies for attracting foreign businesses, and enacting protectionist policies in the form of tariffs. We emphasize that the two parameters are open to flexible interpretations. For instance, a low K may capture a regulatory environment where the government deliberately turns a blind eye to the exploitative practices of the domestic industry. But it may also reflect one where the government simply lacks the technical capacity to understand or detect exploitation in the underlying algorithms. On the other hand, a low theta may capture a market environment where the domestic industry is technologically superior to its foreign competitors, but it may also reflect one where protectionist policy is in place to protect the domestic industry against foreign competition, as in the case of China. Having explained and motivated the subject of our investigation, here is an outline of the model as follows. A representative domestic AI firm is in direct competition with a foreign AI firm. In the first stage of the game, the domestic firm invests in improving the algorithmic efficiency of its AI system. Driven by profit motive, the domestic firm also chooses the degree to which the algorithms covertly exploits the consumers. The two factors together determine the actual value of its AI system. In a second stage of the game, the firm's exploitation is revealed to the consumers with possible positive probability. Depending on their state of knowledge, consumers have different perceptions of the relative values of the domestic and foreign AI systems. The consumers that determine how often they use the two systems accordingly. The profit of the domestic firm amounts to the degree of exploitation of its system multiplied by consumer usage. The actual welfare of the consumers depends on the actual values of the two systems, as well as their usage decisions based on relative perceived values. This provides us with a framework to study the strategic interdependence between innovation and consumer protection. Based on our game theoretic analysis, we have developed an economic theory of how the welfare maximizing level of regulatory stringency for AI depends on various institutional parameters. Under high foreign competition, domestic innovation plays a relatively small role in serving consumers. On the other hand, consumers benefit most when they are not misled to underuse the highly competitive foreign AI systems. As a result, the prioritization of consumer protection should motivate a government to choose a high level of regulatory stringency under high foreign competition. Meanwhile, under low foreign competition, for instance, due to strong protectionist policies, the domestic AI industry can effortlessly win over local consumers from their foreign competitors. This means domestic firms can derive high marginal benefits in terms of market share from improving their algorithms. As a result, the robustness of domestic firms' innovation incentives should motivate the government to also choose a high level of regulatory stringency under low foreign competition. Interestingly, under intermediate foreign competition, the government faces a delicate trade-off between consumer protection and innovation. Too stringent regulation stifles the innovation incentive of the domestic AI industry, whereas minimal regulation subjects the consumers to excessive exploitation. To maximize the actual consumer welfare, the government may strategically lower its regulatory stringency and turn a blind eye on some occasions if strives to maximize innovation. Across all institutional environments, however, minimal regulations are never compatible with maximizing actual consumer welfare. As such, the objectives of such regulatory design may be either rationalized by the prioritization of innovation, domestic producer surplus, or the perceived welfare of the consumers. In the latter, the government is primarily concerned with the image that this regulatory intervention produces without worrying too much about the actual protection of consumers, essentially using a loosely designed regulation as a PR tool. If the government does care about the actual welfare of the consumer, it is always strictly suboptimal to choose a stringency level so low as to induce the firm to fully exploit the consumer. Choosing full regulatory stringency would serve the consumer better, even if such an environment will dampen the firm's innovation incentive. Full regulatory stringency may not maximize actual consumer welfare under some circumstances, in particular when foreign competition is intermediate. At such level of regulatory stringency, the domestic AI industry is incentivized enough to innovate and improve its algorithmic efficiency, but also disciplined enough to leave positive surplus to the consumer. This does not happen when foreign competition is sufficiently high. Under high level of foreign competition, the optimal choice of the government is then to set a high level of stringency, even if it may stifle the innovation incentive of the domestic firm. The reason is that the foreign AI system is a substitute for the domestic one. If the government is solely concerned with the actual welfare of the consumer without any bias towards protecting the domestic AI industry, then it is optimal for the government to make sure that the consumers are not misled by the domestic industry and consequently use the highly competitive foreign AI systems any less than they should. This argument has not taken into account the government's concern for technological dependence on foreign countries, which is an interesting setting that we leave for further studies. Additionally, further empirical studies should pay close attention to cases where governments are proposing very loosely defined regulations for AI, as they may not be maximizing the actual consumer welfare. Thank you very much for listening to this presentation. This is the end of our presentation. You can read the full paper at SSRN via the link that you see on the screen, and feel free to reach out to me if you have any questions. Thank you very much.